that a lengthy finite term will be a sufficiently severe penalty, and this is not such an exceptionally serious case of the utmost gravity, where the sentence of last resort must be imposed on an offender who was 18 at the time and is 19 today. It's argued on your behalf that you are not entirely to blame for your offences because you are autistic and have some psychopathic traits in that you are incapable of feeling empathy or remorse. I'm also invited to conclude that you are less mature than your chronological age. In determining these matters, I have to view the case as a whole. Although you are indisputably a very dangerous young man, the risk to the public is met by the imposition of a life sentence. The aim of sentencing in a case of murder is just punishment for the crime. Just punishment requires a careful assessment of the perpetrator's culpability and the harm caused by the crime. In every murder, the harm is of the utmost severity. Your crimes involved the following: very substantial premeditation, 3 murders on the same occasion but committed individually. Each victim was shot with an illegally held firearm. You acted during hours of darkness on people who had been asleep in their own home. A 13-year-old child was shot in her face while trying to hide under a table. A 16-year-old child was shot in the chest, after which he was stabbed with a knife or knives, causing numerous injuries, including a wound that penetrated his lung before being shot to the head. Your brother endured additional suffering during the attack, in which you used at least 2 weapons. Each victim suffered the anguish of anticipating or being aware of the deaths of others. The fraudulently acquired and illegally held firearm was to be taken to a school to endanger the lives and kill dozens of young children. A murder spree with the sole aim of glorifying the name of the perpetrator in the history of mass killers is what you intended. I have in mind the definitive guideline which assists judges dealing with offenders with mental or developmental disorders and neurological impairments. The guideline makes it clear that while any disorder or personality trait present should be considered, it will not necessarily have any impact on the sentence. Culpability, the degree of responsibility for an offender's actions, may be reduced by reason of any impairment or disorder he was suffering from at the time, but this only applies if there is a sufficient connection between the impairment or disorder and the offending behaviour. A consultant forensic psychiatrist, Dr. Ian Koyman, has produced a full report dated the 5th of February 2025 and an addendum for this hearing dated the 2nd of March. Both reports must go with you to custody, together with the sentencing remarks. Dr. Koyman's conclusion is that although you have not undergone a formal diagnosis, you have traits of autism spectrum disorder, ASD, albeit not to a severe degree. ASD is a neurodevelopmental disorder, not a mental illness. It is individual. In your case, it means that you have persistent deficits in social communication and interaction, and restrictive patterns of behaviour, interests and activities. These explain almost all the abnormal aspects of the way you related to people and obsessed about things that you were interested in, such as school shootings and serial killers. The internet facilitated this through the free availability of imagery and commentary. This means there is an indirect connection between your ASD and your offending, but it is important to note that your ASD does not correlate to an increased risk of violence, nor did ASD in this case impair your ability to understand the nature of your conduct, exercise self-control, or form rational judgments when you decided to commit violent crimes. Dr. Koyman observed that since your arrest you appear to be functioning better, and incarceration has not caused you to suffer as most people would, because you have little need for social relationships. You have expressed pride in your crimes and the attention gained from them. Dr. Koyman makes another apposite observation. The rigidity of your thinking due to ASD explains why, when your plans to arrive at the school at about 9 a.m., when the children would be assembled in the early years class, were foiled, you did not adapt the plan. In addition to ASD, Dr. Koyman found you exhibit an extreme lack of empathy, the ability to understand and share another person's feelings and thoughts, which is important for building relationships. You have also expressed no remorse and no sorrow. Indeed, when asked by the psychiatrist if you would try to commit another massacre, you replied, "Well, that's their job, to stop me getting the weapons if I get released." A lack of empathy and or remorse is not unusual in the criminal population. And Dr. Koyman concludes that these drove your decision to commit mass murder and enabled you to do so. In the section concerned with psychopathic disorders, which these traits align with, the guideline advises judges, if empathy is severely impaired, for example, the capacity to recognize distress in others and make appropriate use of that information, this may severely impair capacity to desist from harming others. I add emphasis to the word may. Each individual and each offence must be considered specifically, without a blanket approach. In my judgment, this brief section of the guideline envisages a situation where an offender's ability to make appropriate use of his knowledge of the distress of others, i.e. a cognitive process rather than an emotional one, is diminished, so that his capacity to desist from harming others is severely impaired. This case is far from that. Dr. Koyman states that although you struggle to consider inherently and emotionally how other people think or feel, that is the extent of your limitation. You are intellectually capable of logically deducing the impact of your actions on others. You told Dr. Koyman you had made the choice to commit mass murder and become posthumously famous. It was your preferred alternative to a menial 9-to-5 job for the rest of your life, which you believed was your future. You made a series of choices to put your own desires above any consideration of the lives of many others. There is no suggestion that you didn't understand the law or that killing people is morally wrong. You just didn't care. You had not previously displayed any difficulty desisting from harming others. The lack of an emotional connection to your victims or sympathy for what they suffered or would suffer had important consequences because it disinhibited you. But in my judgment, it does not reduce your culpability because your cognition and ability to refrain from murder were not diminished. It would be irrational for it to do so when the harm you committed and also intended to commit was obviously so very grave and deliberately so in order that it gained you the benefit of wide publicity and international infamy. If your lack of empathy makes it easier for you to make that choice, so be it, but I do not treat that as reducing your culpability or as a mitigating factor. I've reminded myself of the guideline on sentencing children and young people because considerations of maturity, insight and understanding do not end once an offender reaches the age of 18. You are different to most people, but that does not mean you were or are immature for someone of your age. Your intentions were not immature fantasy. 6 months ago, you were able to defraud an adult considered responsible enough by the authorities to have a genuine shotgun certificate into selling you face-to-face a lethal weapon. Your communications with the man in advance and in person demonstrated a clear understanding of how to reassure a much older and experienced man. Nothing in your meticulous researching and planning over the course of many months indicates immaturity, nor does the care with which you created a clever forgery of a shotgun certificate to defeat the controls on the sale of guns in the United Kingdom. Your claims to the police after arrest that it was not murder show you had thought about what you might say in such an eventuality. Although I have been troubled by this shocking case, axiomatically a case which the judge considers to be on the borderline is not one that cleanly clears the hurdle of enhanced exceptionality. Having dealt with culpability and maturity, the question is whether in ensuring due punishment, the seriousness of the offences overall is such that it is not possible, consistent with my duty to the public, to specify any minimum term. Having reflected, I agree with the parties and do not impose a whole life order in this case. Firstly, because you were thwarted from completing your intentions. Otherwise, this case would have had a very different and even more appalling outcome. Secondly, this prosecution has resulted in guilty pleas. Thirdly, you were 18 at the relevant time, at the bottom of the bracket for the power provided for in section 3213C, and I have available a substantial finite term well above the starting point. I reject the mildly put submission that disruption to your childhood caused by the separation of your parents when you were young provides mitigation for these offences. The evidence is that your father lived nearby and saw you regularly, most recently just 2 weeks before the murders. You had a supportive family. Stand up, Nicholas Prosper. You intended to unleash disaster on the community of Luton. Your plans were intelligent, calculating, and selfish. Your ambition was notoriety. You wanted to be known posthumously as the world's most famous school shooter of the 21st century. The lives of your own mother and younger brother and sister were to be collateral damage on the way to fulfill your ambition. Your plans failed because your mother woke up and realized you had a gun and were determined to use it. This led to an horrific triple shotgun murder, with each victim dying knowing you had killed or intended to kill the others. Words such as heartless and brutal are insufficient to describe the horror of those last moments of the people who were closest to you. I have decided to impose a minimum term. In drawing back from a whole life order, I have already taken into account your age, your guilty pleas, and the fact that you did not carry out any violence after you left your flat, despite having reloaded the shotgun. To account for the aggravating features overall in this case, the minimum term you must serve has to be increased very significantly indeed from the Schedule 21 starting point of 30 years. I remind you that each of the 3 murders you committed would reach the threshold for a 30-year minimum term on its own. The increase I impose is the least possible in all the circumstances. There is no mitigation beyond those matters I have already taken into account. On count 1, the sentence is 3.5 years custody concurrent. On each of counts 2, 3 and 4, I impose concurrent sentences of custody for life with a minimum term calculated from 49 years, from which the time you have already spent on remand must be deducted. Council have calculated this as 188 days. If that is incorrect, the case must be listed so it can be corrected. The sentence on those counts is therefore custody for life with a minimum term of 48 years and 177 days. However, you remain highly dangerous and it may be that you will never be released. On count 5, the sentence is custody for life with a minimum term of 18 years concurrent. This is a discretionary life sentence under section 274 of the Sentencing Act. On count 6, the sentence is 1 year custody concurrent. I order forfeiture of the shotgun, the cartridges, the knife and the phones. Finally, I repeat my observation that Juliana Falcon, Carl Prosper and Giselle Prosper's deaths are almost certain to have saved the lives of many children. The community owes them its gratitude and their memory should be honoured. Please take Mr. Prosper down.
They now have this big minimum term imposed on him. There was a question for the judge there as to whether he should receive a whole life order or he would never be considered for parole. He decided, given his age, he was 18 at the time of these killings and the fact that he pleaded guilty a few weeks ago, that he didn't quite reach that standard. But nevertheless, a very long minimum term imposed on him. And this is a teenager who craved notoriety. He researched those school massacres in different parts of the world, and he had a detailed plan as to what he wanted to do at his own primary school that he had left many years earlier. He had no particular grudge against that school. He just craved and notoriety, but it was actually his own mother who denied him that opportunity, who ruined the plan that he had carefully worked out over many months. And this is the story of how that teenager got to that point here in Luton, and police make this triple murder.
He has time served, of course, having been arrested earlier last year. So with that time, just over 13 years in prison, but that's before he even considered the sex before he is eventually released. Clearly, the judge had to take into consideration whether in this case he convicted his mother and two of his siblings murdered on him, whether it was justified the whole life of taking all of the consideration, including the fact that he was suffering from autism spectrum disorder.
Yes, I do.
So the issue that a whole life child is not justified in this instance, and that's why she was demanding a minimum term of 40 years. This case happened on the 13th of September last year, and the living murders of English teachers
Yeah, okay.
Juliana, who's 13 Giselle, and 16-year-old brother Tyler, actually got the flats he lived in Luton. This was the preparing for a much greater tragic disaster in Luton, according to the judge, because it was Giselle Prosper's plan to go armed with a shotgun that he could use to kill his
Seriously,
family.
I actually think it was better to leave a bit more of a gap, because there are a couple of grabs from that in this routine.
Luton, and specifically he was going to target those very young children, years cohort after.
Yeah, there will be a
the Arabella one
Yeah.
Yeah, I can. It's just
So it's in terms of questions arising from this sense.
No, it's fine. I can do the sentencing one. That's not a problem. We'll do the sentencing one.
Columbine and Virginia Tech as well. These school massacres that still ring for most people, with the tragedy that occurred. These schools should be prevented to emulate those mass murderers and actually to outrage. But on that day, the 13th of September last year, when we looked to shoot dead those family members,
In passing that sentence in the last few minutes here at Luton Crown Court, the judge said that Giselle Prosper expressed no remorse and no sorrow. And when he was asked if he would try to commit another massacre if he was released, his words were, well, that's their job. Stop me getting wet. The judge said that he very clearly chose to put his own desires above the lives of others. There's no suggestion, he said, that he didn't understand the law, he just didn't care. This is a very disturbing story for that school community in Luton that we have to try and understand how they became the focus of his planning. And it was purely his direct connection, having attended the school, that is why he wanted to go there, because he knew the institution. It wasn't that he had a particular grudge against anyone at the school, but his sort of planning and research was discovered after his arrest. He didn't say anything in the formal police interview, but when he was inside Bedford prison, Giselle Prosper disclosed to a nurse his plan in a conversation that went on for an hour or more. And within that, he explained precisely what he wanted to do, how he was supposed, in his mind, to kill his family members in their sleep so there would be less of a disturbance. because his mother found him with that shotgun inside his bedroom late at night, then that brought his plan forward. There was commotion, a lot of noise of the shotgun being fired. It went on for over an hour with violence inside that flat, in which he also killed his 13-year-old sister Giselle and his 16-year-old brother Kai. And that put his plans into fast forward. He knew the police would be on their way, responding to the neighbours who heard this incident unfolding in the middle of the night. He left the flat very early and had that 3-hour window between the murders and when the schools would be open. He planned it for that Friday morning, emulating some of the things that other school shooters have done in other parts of the world. There was a very disturbing online life that Nicholas Prosper led. A number of indecent images of children were found on his devices, and he believed that he was in a relationship with a young girl who was a character in a video game called The Walking Dead. His internet history provided the police with much of the evidence that they needed to show that this was what had happened, and the fact that he was, for a year or so, had this interest in guns and massacres and killings. And they know that he bought that shotgun the day before he murdered his relatives. He had arranged with a legitimate firearms dealer to buy a shotgun from him at £650 He did that by forging to a very high standard of firearms certificate that convinced the seller that he was legitimate, and he was given £30 to take him to drive here to Luton to deliver the guns to this then 18-year-old. Police investigators that he were confident and happy that it was a genuine error of judgment on his part and was due to buy he took that shotgun back into the flat. We know that he killed his mother, his brother and his sister, and was then on his way to that school the following day when police patrol who knew about shootings had been reported to the police in those early hours of the 13th of September, and they stood on the side of a road. He seemed to wave them down or make some kind of gesture towards him. At this point, he hidden the shotgun and cartridges nearby so that he didn't draw attention to himself. When he was arrested by the police, he repeated, "It's not murder, it's not murder." He said it over and over again. When they took him to the police station in the custody interview later that day, he refused to answer any questions, simply responding no comments to every question that was put to him. And police, over the following weeks and months, with that information from the person that he disclosed to learn about the plan for the school massacre, notes, handwritten notes that they found. Yes, he told me from various representatives of federal police and also the Crown Prosecution Service. It raises many questions about his internet usage. How was this 18-year-old in his bedroom in Luton able to simply research school massacres seemingly unchecked? He found most of the information he needed from the surface web. So this wasn't the dark web and hidden corners of the internet. This was freely available information that took an 18-year-old to the point of almost committing a school massacre. There were questions too about the ease with which he was able to buy that shotgun the day before, and that is something that I know that there will be further questions about and calls to tighten the rules around the sales of shotguns. But in her sentencing remarks, the judge also acknowledged that he had autism spectrum disorder, but she was satisfied that it didn't affect decision making enough to be a reason for why this happened, or the primary reason why this happened. This was something that Nicholas Prosper researched, something that he knew what he was doing, and he expressed no remorse. He's someone who analysts have found has very little ability to express remorse or empathy for either his victims or anyone else. It is a family tragedy, this story. We saw his father, Raymond Prosper, in court crying at points during the sentencing hearing here in Luton in the last hour or so. And we heard from him yesterday in a statement that was read out in court, the victim impact statement. Raymond Prosper said, "Our lives will never be the same." For me personally, when I heard the horrific news on that day, part of my soul died too. This is a lose-lose situation for us all, and we've lost 4 family members. His former partner, Juliana, his son, his daughter, and his older son, Nicholas Prosper, who is now starting a very long prison sentence. He will be in his late 60s before he is considered for parole. Yes, and it is one of the most severe minimum terms imposed in the country, certainly in recent years, but it reflects the gravity of his offences, the premeditation of the murder of his 3 family members, and also illegally obtaining a shotgun the day before via deception, and the scale of planning of what he planned to do at his former primary school is, of course, factor in the calculations around this case. The Crown Prosecution Service has worked very closely with their witnesses on this case. They described him as a cold and calculated killer, and the revelation of his plan to shoot classes of school children and their teachers left his family devastated and an entire community in shock. We've spoken to some of the parents from that school, and it's understandably a very difficult story for them to digest and understand, but it is something that the school and the authorities really need to try their best to try to make sure that they are protected, and that school security is, of course, at the forefront of people who run these organisations. It was the very earliest year group that Nicholas Prosper has wanted to target at his old school, 4 and 5-year-old children. It is disturbing on so many levels. The actions of his mother, interrupting him in his room, disrupting his class, was something that stopped him attaining that notoriety that he craved. We will, as I say, be hearing more from police. Luton further statement from Raymond Prosper, led by one of the senior police officers who has been in court. Yes, he says he refused to stand for that moment of sentencing, and he issued this morning refused to come to court. The judge was not having that. He ordered it. He thought into the shop. This had happened around 11 o'clock or so, and he was then presented from this listening to that very clear, very troubling outline of the case that the judge summarised in the last hour. It is a very chilling case which has many difficult aspects. Availability of information online is one of the things that the police have told us is something that they can't tackle alone. They need the help of tech companies and also governments around the world to ensure that the materials that Nicholas Prosper accessed to bring him to that point of almost becoming a notorious school killer, that information is somehow checked and removed from the internet, but that is a very difficult thing that the police say they can't tackle alone. Yeah, we'll have a minute warning.
it's not a whole lot of change the ground and the down.
Can do if you want me to. Yeah, I'll be off camera.
Well done, Tom. That was a lot of air tonight.
There's quite a bit on it.
Do you want to talk into them? I can just move it over the window.
Yeah, I'll move it in if they do want to come to us.
So in the end, the judge, this is just this team decided that a real life error is not sufficient.
You got to go again in a minute.
Maybe.